Okay, let's dive right into this explainer. Today, we're unpacking a honestly, truly fascinating development happening in the legal world right now. We're looking at the Supreme Court of India's draft Regulations for Use of Artificial Intelligence in Courts 2026. And we're going to explore this through the lens of a really sharp analysis by data governance expert Vijayashankar Naavi. You probably know him as Naavi. He took a magnifying glass to this entire framework, and what he found is basically a masterclass in both wild ambition and, well, unintended consequences. So if you're curious about how the actual future of our justice system is being coded right this very second, you are definitely in the right place.
But right out of the gate, we've got to ask ourselves a critical question. While bringing artificial intelligence to the justice system is a massively bold move, the execution, it could be incredibly costly. I mean, the dream here is amazing. Faster case resolution, way better legal research, streamlined admin work. But the reality of managing the tech that powers that dream, it requires a staggering amount of resources. Let's look at the foundation first.
Section 1, the AI Courts Framework, a global standard.
Starting with the overwhelming positives found in this draft framework, it's really important to note that this isn't just a handful of loose suggestions. Naavi actually broadly welcomes the Supreme Court's draft. He points out that it's one of the most comprehensive judicial AI frameworks currently existing anywhere in the world. I mean, the Supreme Court hasn't just dipped a toe in the water here. They've basically mapped out the entire ocean. They're recognizing that AI is the undeniable future of the judiciary, and they're actively trying to put the guardrails up before the tech just completely runs away with the system.
Section 2, a private sector template, setting the baseline. Now, here's where it gets really interesting, because this framework isn't just for judges and lawyers. It actually reaches way beyond the courtroom doors. Naavi points out that this draft effectively serves as a super strict due diligence template for the entire private sector to follow. By setting such an incredibly high bar for AI governance, the Supreme Court is indirectly telling tech companies, corporations, startups, everyone, hey, this is what responsible AI actually looks like. It sets a totally robust, undeniable baseline for private sector AI governance. In fact, Naavi notes it heavily validates his own established DGPS AI data governance framework. Think about it. If the highest court in the land requires this intense level of auditing, testing, and safety, you better believe private businesses are going to be expected to meet a very similar standard.
Section 3, the bureaucracy warning, over-engineered governance.
Okay, so despite its brilliance, Naavi has one massive warning for us. This structure is dangerously over-engineered. This is where the sheer ambition of the project kind of crashes headfirst into logistical reality. According to his rough estimates, running this framework exactly as it's drafted right now would require an astounding 1,000 personnel. Yeah, 1,000. We're talking about a massive, sprawling, new bureaucratic arm made up of AI experts, auditors, compliance officers, and tech folks, all needing to be seamlessly integrated into an already super burdened judicial system. And as you might guess, those 1,000 experts, they definitely don't come cheap. To pay for that massive bureaucracy, the courts are staring down an estimated annual operating cost of 250 to 300 crore rupees. And remember, that is purely operational expense. That's just the yearly reoccurring cost strictly to keep the lights on and the salaries paid for this giant AI governance structure.
Oh, and that doesn't even count the initial setup. The framework demands a massive capital expenditure of over 300 crore rupees right out of the gate. We're talking hardware, infrastructure, software licenses, the whole architectural setup. When you stack those setup costs on top of the yearly running costs, well, you start to see exactly why Naavi is ringing the alarm bells so hard about financial sustainability.
Section 4, the centralization solution, fixing the duplication.
So those financial numbers are totally staggering, right? But the core problem isn't actually the AI itself. The problem is how the draft is asking the courts to manage it. The current draft mandates duplicate AI committees, individual secretariats, separate incident databases, and highly specialized forensic lab-like AI content verification authorities at every single high court across the entire country. Literally every single one. So instead of duplicating massive forensic labs and committees all over the place, Naavi says we absolutely must centralize oversight. He proposes bringing all of this under one single grand committee of High Court Chief Justices, or maybe one national expert team. You know, build the really expensive infrastructure once and just let all the courts use it. Makes a lot of sense, right? Because if we don't centralize, the risks are pretty severe. Without a unified approach, he warns we're going to see a massive duplication of effort and just so much wasted money. Even worse, we could start seeing conflicting legal decisions regarding AI, Like, imagine an AI tool gets approved by the Delhi High Court, but totally banned by the Bombay High Court. What a mess. And honestly, perhaps the biggest risk of all, overwhelmed high courts that are already struggling with massive case backlogs might take one look at these impossibly complex, highly bureaucratic AI directives and just ignore them completely.
Section 5. The Data Privacy Trap, Clashing with the DPDPA. Now, beyond the money and the bureaucracy, introducing AI into courts isn't just an IT issue, it's fundamentally a data privacy issue. The draft framework broadly labels judicial information passing through these AI systems as sensitive judicial data, which on the surface sounds like a perfectly reasonable categorization. You obviously want court records to be highly protected, but in the complex world of modern data privacy law, that specific phrasing actually triggers a massive legal tripwire. Here is why. The moment you start officially hoarding and processing massive volumes of what you legally define as highly sensitive data, boom, you trigger the Digital Personal Data Protection Act, or the DPDPA. By doing this, the courts could entirely by accident classify themselves as significant data fiduciaries. And being a significant data fiduciary is no joke. It means you're subjected to intense external legal scrutiny, heavy compliance obligations, and potentially some really steep penalties. And here is the really harsh reality. Courts don't automatically get a free pass from these strict privacy laws. Just because they are the judiciary doesn't mean they're magically exempt from the exact same data protection laws that govern the rest of the country. If they process sensitive data, they are caught in the exact same legal web as any massive tech corporation out there. So, how in the world do we avoid this legal trap? Well, Naavi lays out a really clear, highly practical legal fix. He recommends that the Ministry of Electronics and Information Technology, MITE, step in proactively. They basically need to officially notify the court systems as exempt using Section 17.2 of the DPDPA. This one simple, bureaucratic fix essentially untangles the courts from that massive compliance nightmare, allowing them to actually use AI securely without accidentally breaking the nation's own data privacy laws. At the end of the day, solving these bureaucratic and legal bottlenecks matters to all of us. You know, you might be watching this thinking, I'm not a lawyer, why should I even care about court IT budgets? Well, you should care, because efficient courts mean better access to justice for everyone. If the courts are spending all their time and money fighting their own over-engineered AI bureaucracy, they aren't spending that time clearing the backlog of millions of cases that affect everyday citizens. We absolutely need this technology to work, and we need it to be legally sound. Which really leaves us pondering this massive challenge for 2026. The ambition is clearly there, the technology is ready, and the private sector is definitely watching closely to see the standard that gets set. But the execution completely hangs in the balance. Will the courts actually heed this expert advice, centralize their oversight, and streamline their AI dreams? Or are they just going to drown in their own incredibly expensive, decentralized bureaucracy? It is a truly fascinating space to watch. Keep learning, keep questioning, and I'll catch you in the next explainer.